to start your introductions.
Hello, my name is Bethany Bridgham, and I am the Senior Associate General Counsel for American University. I was asked by the American Political Science Association to provide this session on legal issues for department chairs for the APSA membership. Department chairs are among the few individuals within the college and university setting who have responsibilities on both the academic and administrative sides of the institution. Department chairs are asked to fulfill managerial, academic, and supervisory functions while also issue spotting potential legal problems and understanding the institution's policies and procedures to guide them through these tasks. Ideally, your institution would have a well-developed training program for new department chairs, which would explain your new role and responsibilities, as well as the institution's key policies and procedures and the federal and state laws which will impact you in your new role. Unfortunately, most institutions don't have this ideal training program, and instead, many department chairs are left to learn as they go. The danger to this approach is that so many of the institution's policies and procedures are process-driven. If a chair is not conversant in those processes, he or she may be unintentionally violating those policies and procedures, creating unnecessary liability and legal risk. A department chair should also understand the limits of his or her authority, which again goes back to having a firm grasp of your institution's policies and procedures. What I hope to accomplish here today is to provide each of you with a roadmap highlighting the typical issues which might come across your desk as a department chair and identify resources to help you address those issues before they escalate into much larger problems. So now that I've listed all the possible things that might cause issues for you, let me assure you that you will not face these issues alone. Each of your institutions should have an indemnification policy. Generally, indemnification policies provide that if you are acting in good faith and within the scope of your employment, the university will indemnify you for these actions. Practically, this means that if you are sued for actions you took in your role as department chair, the university will provide you with legal representation to defend you against the claims made challenging your actions. Unfortunately, because of the litigious nature of our society, it is highly likely that at some point in your time as department chair that you will be sued or threatened with a lawsuit. While I recognize it is easier said than done, I would encourage you not to take it personally. Normally, you will be named in a lawsuit because of your professional role as department chair and not in your individual capacity. If a lawsuit does materialize, your Office of General Counsel will step in and, I hope, be able to resolve the issue with a minimal amount of angst for you and your institution. If you are not familiar with your Office of General Counsel, I would encourage you to pick up the phone and introduce yourself. The office is a resource for you and the entire institution. The General Counsel's office exists to represent the legal interests of your school with the entire institution as its one and only client. The General Counsel's office does not provide legal advice to university employees for personal matters. For example, we won't draft your will or provide advice if you're getting divorced. As a department chair, when a problem does arise, I would strongly encourage you to address it quickly rather than running the risk that it will mushroom into something much larger. However, this doesn't necessarily mean that your first call should be to the General Counsel's office. Your first call might be to your dean, asking for guidance or consultation to determine what the next steps might be in accordance with your institutional policy. Remember, the General Counsel's job is not to tell you what to do. As department chair, it is up to you to decide what course of action you want to take, which is consistent with the institution's policies. It is the General Counsel's role to evaluate that decision for potential legal issues and problems, determine if it complies with applicable university policies, and if legal barriers are identified, to provide alternatives to help you reach your desired outcome. As a department chair, whether it is a large or small department, More likely than not, you will find that the majority of the issues you face will be employment related. These might include promotion and tenure, hiring, performance issues, internal grievances, requests for disability-related accommodations, or complaints about harassment or alleged discrimination. In each of these situations, the key is to understand your institution's policies and apply them objectively and fairly, be consistent in their application, respond timely to issues, and use legitimate business criteria as outlined in those procedures for making your decisions. For the most part, courts have shown a great deal of deference to the decision-making of colleges and universities, so long as those decision-making processes have not been arbitrary or capricious. However, failure to follow procedures may encourage the court to step in and overturn your decision. At a public institution, federal and state laws will be the primary source of guidance in addressing employment issues. For private institutions, this guidance is generally found by looking at a faculty member's contract, which will generally incorporate the parameters of the faculty handbook, which outline the due process available to faculty members, or the staff handbook for members of the staff. It's imperative that you not ignore performance problems. They rarely fix themselves. Performance issues should be addressed in a timely manner so that a record of progressive discipline or counseling can be established. It serves the best interest of the faculty member or the staff member, as well as that of the institution, because expectations have been made clear and the consequences for not meeting those expectations have also been enunciated. If the performance problem evolves into a legal matter, having that record of progressive discipline or counseling will provide a firm foundation for a solid defense. As in-house counsel, I will say it is extremely frustrating to receive a request for assistance in dealing with what's described as a long-time problematic employee, only to find out that the manager has failed to document performance deficiencies or the progressive discipline which was used, which resulted from a failure to meet clearly delineated expectations. Even worse is to find a folder of past evaluations which indicate that the employee has met expectations because the manager wanted to avoid the difficult conversation of documenting performance problems. Be mindful of regularly, fairly, and accurately appraising performance so that you have a foundation to take action later on. What other options exist for you to deal with performance issues? Seek out your institutional resources, which for a faculty member might be what we call the Center for Teaching Excellence, which can help address teaching deficiencies. Your Human Resources Department likely has similar resources for staff, whether it involves online training modules or interactive trainings to work on specific skills. The most significant difference between the status of faculty and staff as university employees is that faculty are generally protected by tenure and have a faculty contract, while the vast majority of staff are considered at-will employees. As a general rule, if employment is at will, it may be terminated at any time, whether or not there is cause, whereas tenure will generally protect a faculty member from being terminated without cause. Although tenure is generally viewed as providing lifetime job protection, the awarding of tenure does not mean that your duty as the department chair to continue to evaluate that professor's job performance ends. Instead, I would encourage you to continue to conduct post-tenure performance reviews, such as annual merit reviews, to incentivize excellent performance and set the tone for your department that performance matters and performance problems will be addressed. Within the broader topic of employment issues, I would like to spend a moment talking about hiring. As department chair, it is more likely than not that you will be involved in hiring decisions. Because of higher ed's long relationship with shared governance, who gets hired has an outsized impact on the long-term health and goals of an institution. This includes making every effort to ensure that your hiring process has been designed with a conscious effort to create not only a diverse pool of applicants, but also a group of applicants who believe that the institution and your department are sincere in creating a diverse and inclusive environment where he or she can be successful in their career. Consequently, as the department chair, you should be motivated to make sure that you've done everything in your power to get it right. As the department chair, you should be aware of the standards outlined by the AAUP in the ethics of faculty recruitment, as well as your institution's policies regarding affirmative action, non-discrimination, and commitment to build a diverse and inclusive community. Reach out to your human resources department to ensure that appropriate recruiting, interviewing, and selection processes are followed. As department chair, you should strive to be able to demonstrate that choices between candidates were based on legitimate, non-discriminatory, and job-related reasons, and those items were applied consistently to each candidate. These guidelines should be applied at every stop in the process. For example, the job description should be clearly written and based on objective, neutral criteria. When you advertise for candidates, identify both formal and informal sources to make sure that you have a broad and diverse network. The appointment and training of your search committee means that you provide them with the help to produce the best search possible. Number one, you want to make sure that the people that you've appointed are a diverse selection of the members of your department. You also want to include meetings with HR and your affirmative action officials so that they can answer any questions the committee might have about how to conduct the search. When you screen candidates, it is important to ensure that the candidates are screened using the same objective criteria, which is applied to every candidate. One way to do this is to craft evaluation forms beforehand to ensure that every candidate is judged using the same criteria. When you bring candidates in for interviews, it's important that you make sure that the questions that are posed to these candidates are strictly job related. And one of the easiest ways to do this is to draft permissible questions for interviews to use before the candidates arrive. This will also allow your faculty members who will be conducting the interviews to ask questions about what may or may not be permissible. For example, if you have a position that requires extensive travel or teaching on nights and weekends, your department would be legitimately concerned that a candidate understands the unique demands associated with the position. However, your interviewer cannot ask if the applicant's spouse will support those type of hours, or if the candidate is a woman, whether that non-traditional schedule would interfere with her childcare responsibilities. However, it is permissible if the interviewer asks every candidate if he or she understands that the position has non-traditional work hours, often requiring nights and weekends, as well as extensive travel, and that those requirements are an essential function of the position. When you're ready to make the job offer, again, go back to your university's policies and make sure you understand who has the authority to make the offer. Often, job offers are limited to your chief academic officer, a provost, chancellor, whoever it is that holds that position at your institution. As the department chair, you should avoid making any oral or written representations if that authority has not been delegated to you. Additionally, Any job offer should be contingent upon checking and verifying the candidate's credentials and references. Some institutions also include passing a background check, which may include both civil and criminal elements. You need to pay attention to this issue if your institution is in a so-called ban-the-box state, which generally describes jurisdictions which prohibit employers from asking if an applicant has a criminal record until after an offer of employment has been made. If you are in a ban-the-box state, you cannot ask about a candidate's criminal history until after you've made an offer of employment. Consequently, it's important that your offer letter clearly state that the offer is contingent upon resolving any questions related to disclosures on the applicant's background check. After employment issues, as the department chair, you are likely to find that allegations of discrimination and harassment are likely to be the most frequent type of complaint from the members of your department. It is imperative that you take any complaint related to discrimination or harassment seriously. How you address these complaints initially may very well mean the difference between being able to achieve a satisfactory resolution quickly versus being dragged into a protracted legal battle. As the department chair, individuals will look to you to set the tone for the department, which includes the responsibility of developing and sustaining a department which values respect and inclusion for all members. Just as performance problems need to be addressed in a timely fashion, if you witness or others identify potentially discriminatory behavior or harassment, it is incumbent on you to address it quickly. As the department chair, you should take the individual aside and let him or her know that concerns about his or her behavior have been brought to your attention or witnessed by you. This is your opportunity to remind this individual what your institution's expectations are and what your expectations are for appropriate behavior within the department. You should familiarize yourself and the members of your department with your institution's non-discrimination and anti-harassment policies. In the event that you do see troublesome behavior, you will be able to clearly and succinctly explain to an individual why the behavior is of concern and what the university's policy says about that type of behavior. In addition, many institutions have policies that impose a duty to report if faculty are aware of discriminatory behavior. Individuals should be aware that if they do not change their behavior or it escalates, you may have no choice but to report it and take action. Laws such as Title IX have also codified reporting duties for individuals within the university structure, which includes ensuring that the individual making the complaint receives information about options and resources. Keep in mind, the majority of people find it difficult to come forward with a complaint. They're concerned about being viewed as a troublemaker or that their concerns will be brushed aside. As noted earlier, you should address all complaints in a serious and professional manner. Remember, the standard used to judge whether or not behavior rises to the level of actionable harassment is that of the perspective of a reasonable person in the complainant's position and within the social context where the conduct took place. It is not your opinion as department chair or that of the individual accused of engaging in the harassment. Exercise the utmost discretion when sharing information about this complaint with others in your unit. Only those individuals who have a need to know based on their institutional responsibilities should be informed of the complaint. Failure to exercise discretion in sharing information about a complaint could potentially open you up to personal liability in the matter if an individual could show that you shared the information in violation of your institution's policies or in bad faith. In addition to using discretion in the handling of the complaint, as the department chair, you must also ensure that the individual filing the complaint or anyone who has assisted that individual, such as a coworker acting as a witness, is not subject to any acts of retaliation. In matters involving Title VII or Title IX complaints, an individual does not have to be successful in adjudicating the underlying claim. A retaliation claim will be treated as a standalone issue, regardless of the outcome of the original complaint. The number of retaliation complaints has increased exponentially, and juries often seem to be sympathetic to claims that there is a connection between the filing of the original complaint and any subsequent adverse action. If an individual believes she was retaliated against, in order for the retaliation complaint to move forward, she must show that she was engaged in a protective activity which led her employer to take an adverse employment action against her, and that there is a connection between the two. In these situations, your institution would have the opportunity to show that it had a legitimate, non-discriminatory reason for its actions. For example, if every member of your department is asked to take on additional administrative or advising duties, it is unlikely that it will be seen as an adverse action based on the filing of a complaint. Conversely, if the complainant is the only member of your department assigned to additional duties, it is more likely to look like an act of retaliation. Going back to the larger topic of discrimination issues, there will be some differences in the application of federal, state, or local laws pertaining to complaints, depending upon whether you're a public or private institution. Generally, your institution is prohibited from engaging in discriminatory actions toward any individual who is a member of a protected class. These protected classes include race, color, national origin, religion, sex, age, for those people who are age 40 or older, disability, and veteran status. In some jurisdictions, sexual orientation is also a protected class, while other localities, such as California, also provide protection based on pregnancy, medical conditions, marital status, and ancestry. Most colleges and universities are subject to the following anti-discrimination laws. Title VI of the Civil Rights Act, which prohibits discrimination on the basis of race, color, or national origin in educational settings. Title VII of the Civil Rights Act, which prohibits discrimination in employment based on an individual's race, gender, or national origin. Title IX of the Education Amendments of 1972, which prohibits discrimination on the basis of sex in education programs. The Equal Pay Act, which prohibits sex-based wage discrimination between men and women in substantially similar jobs. The Lilly Ledbetter Fair Pay Act of 2009, which allows for complaints related to compensation discrimination. The Americans with Disabilities Act, which prohibits discrimination against individuals with disabilities in employment, public services, and public accommodations, such as colleges and universities. The Age Discrimination Act and Age Discrimination and Employment Act of 1967, which makes it unlawful to an institution to discriminate against any individual in employment decisions because of age. This one's important because in 1994 it was amended and it removed the mandatory retirement age of 70 for faculty members. Although this is not an interactive session, we did receive several questions from members beforehand asking that we address them in this overview. This seems like a good place to take a break and answer one of those questions, which asked about broaching the topic of retirement with a senior faculty member who needs to retire. We were asked, how can you have a gracious, honest conversation without obsessively worrying about an age-related lawsuit? Before you approach this conversation with your senior faculty member, make sure you understand what retirement programs and post-retirement services your institution offers. This might include conversations with HR and the provost's office. Does your institution offer phased retirement options? And what opportunities exist for a senior faculty member to remain engaged with the institution, even if they're not actively teaching or undertaking research? The demographics of higher ed show that it employs a higher number of older workers than other industries. Most senior faculty members have been at their institutions for over 20 years, and many view retiring as a loss of their identity. So in addition to addressing the legal and more practical matters as part of this conversation, you should also be prepared to address these more emotional ones as well. Going back to the original question, how would you approach the conversation with this particular senior faculty member? Generally, as the department chair, you should avoid asking specific faculty members when they intend to retire, as this could easily be perceived as age discrimination. When discussing the hiring process, we discuss the importance of adhering to legitimate, non-discriminatory, and job-related reasons in distinguishing between candidates. Likewise, if you wish to broach the topic of retirement, you should approach it in a standard, neutral, and even-handed way with the inquiry directed at a broad audience. For example, you could pose it as a request for each faculty member to provide you with an outline of their plans for the next 3 academic years in order to assist the department in planning for hiring, adding or dropping course offerings, and making course, committee, and advising schedules. You may find that this broad, neutral inquiry might be the opening a senior faculty member needs to initiate the discussion about retirement. If you wished to target a more specific population, you could make an inquiry of all professors who meet certain age, such as 50 and older, and service, at least 10 years of service requirements. You could also distribute to all members of your department information about the retirement resources and programs that your institution offers, with a reminder that you are available to answer any questions. Or consider working with your HR department and your retirement plan vendor to hold a workshop for your department on planning for retirement. Invite your members to bring spouses or other family members. Sometimes people are looking for an opening to start a conversation. Finally, if you believe that your senior faculty member needs to retire because of performance issues, I would encourage you to go back over the steps we outlined in the discussion of addressing poor performance. Do not ignore performance problems because they do not fix themselves. Address it in a timely manner. Provide regular, fair, and accurate performance appraisals, which will provide you with the foundation for initiating the conversation related to the poor performance and what options exist for remedying the situation. Another APSA member question wondered, how would you address compliance with the requirements of Title IX balanced with the principles of academic freedom while covering sensitive issues in class? At the risk of sounding like a broken record, my first recommendation is that you read your institution's policies on Title IX compliance and the faculty manual guidelines on academic freedom. Next, consider starting a conversation with your Title IX coordinator to ask if he can assist you in brainstorming ideas to address this issue. As you work your way through these issues, remember that academic freedom is a principle to which the majority of institutions aspire, but Title IX is the law. Violations of Title IX will have real legal consequences. The challenge in addressing this question rests on the interpretation of the terms of your school's policies. You should understand the difference between sexual misconduct and sexual harassment based on speech. Some argue that recent Title IX decisions have gone too far in expanding the definition of what amounts and types of speech create a hostile environment in violation of Title IX, whether that occurs in the classroom or work environment. Ideally, your institution's policies should distinguish between speech, which meets the definition of a hostile environment, from speech that individuals might find offensive or hurtful, but is otherwise protected by academic freedom. In 2013, the Department of Justice and the Office of Civil Rights issued a joint letter which addressed this concern. In that letter, DOJ and OCR stated that Title IX is intended to protect students from sex discrimination, not to regulate content of speech. The offensiveness of a particular expression as perceived by students standing alone is not a legally sufficient basis to establish a sexual hostile environment under Title IX. For more information on this issue, I would suggest the AAUP report entitled The History, Uses, and Abuses of Title IX, which can be found on the AAUP website. I am now going to turn to the issue of disability accommodations for faculty, staff, and students. The American with Disabilities Act prohibits discrimination against individuals with disabilities. As department chair, you may find yourself addressing both requests for accommodations for disabilities as well as allegations of discrimination based on a disability from faculty, staff, and students. In addition to prohibiting discrimination against individuals with disabilities, the ADA also requires employers and institutions of higher education to make reasonable accommodations so that an employee may perform the essential function of the job and a student may participate in the academic offerings and programs. I'm going to address the ADA in employment terms first, and then briefly touch on ADA issues as they relate to students. In either situation, however, my first piece of advice would be that when an ADA matter arrives on your desk, you should review your policy. If the appropriate response is not clear to you, you should reach out to the resource offices at your school. Likely, this means the HR department for faculty and staff and the disability support services for students. Ask them for assistance in understanding the issues and mapping out your next steps in addressing them. The ADA provides that an individual is considered disabled when a physical or mental impairment substantially limits a major life activity. Your policy should provide a framework for an employee to request an accommodation for his disability, outline what medical documentation is required to support the request, and generally describe the interactive process between the parties that is required after a request for accommodation is made. It's important to remember that the accommodation request must be made by the employee and cannot be assumed by the institution, as discrimination against someone with a perceived disability is also considered a violation of the ADA. In order to determine what accommodations are reasonable, the parties must engage in an interactive process where the employee provides information about his limitations and the parties discuss possible solutions which would allow the employee to fulfill the essential functions of his job. The parties are required to engage in these discussions in good faith, and neither party is allowed to insist on a particular accommodation as the only solution. Your institution is allowed to ask for medical documentation of the disability and how it impacts the employee's ability to perform his job requirements. Assuming you have a well-drafted policy, its terms should require that the employee will cooperate with requests for providing this information and the consequences of failing to do so. You may ask that the documentation include a description of the specific accommodation requested and the employee's suggested remedy. The process for addressing disability accommodations from students is very similar to that described for employees. However, you will find that your disability support services plays a much larger role in addressing an ADA issue when a student is involved. As a first step, if you do receive a student request for accommodation based on a disability, you should reach out to your disability support services office, as it will be this office which coordinates the collection of the medical documentation and other required information and will take the lead in engaging in the interactive process to determine what the reasonable accommodation might be for this student. It might include something simple as note takers in class or additional time allotted for test taking. Again, it's not up to the student to solely decide what accommodation she believes is necessary. and you or your faculty member will have the opportunity to participate in the process. One of the things that we have found is that more and more requests for disability accommodations involve the use of a service or emotional support animal. There are significant differences between the two and the rules which apply to each. A service animal is any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Other types of animals are not service animals. Technically, miniature horses can also be considered service animals, but it is very unusual to see a request for a miniature horse in the higher education setting. A service animal has been trained to perform a specific task or tasks which are directly related to the person's disability. For example, a guide dog for someone who is blind or has low vision. A service animal does not provide emotional support, comfort, or companionship. If you receive a request for the use of a service animal as a reasonable accommodation, you're very limited in what information you may request in response to that request. You cannot question the nature or extent of a person's disability or ask that the dog perform the tasks he is trained to do. If the work performed by the animal is not readily apparent, i.e., a guide dog for someone who is blind, you are limited to two questions. One, is the animal required because of the person's disability? And if the response is yes, your second question is, what work or task has the dog been trained to perform? Once that information has been provided, you cannot ask the individual to provide documentation that the dog has been trained, licensed, or certified. Once it has been designated as a service animal, the dog must be permitted to accompany the individual anywhere on campus that the individual goes. However, there are some situations where you can deny a service animal access to campus. These would include one, where the dog's out of control and the owner has not taken effective action to control it. You do not have to tolerate a dog which is unleashed or barking uncontrollably or jumping up on other people. The second situation is if the dog is not housebroken. If the dog isn't housebroken, you can ask that it be removed until it is housebroken. 3, if the dog poses a direct threat to the health and safety of others, where the threat can't be eliminated or reduced by a reasonable modification, you can ask that it be removed. So an example of this would be if someone else in your department or in the classroom has a severe allergy to the dog, it would be reasonable to rearrange a work schedule or a room assignment so that the dog could continue to fulfill its duties as a service animal and your other employee or student could continue to come to work or attend class. Emotional support animals or assistant animals can be almost any type of animal imaginable and play a much more limited role than service animals. Emotional support animals do provide emotional support, comfort, and companionship, and can be anything from a snake to a cat. However, emotional support animals are limited to university housing. So any request for accommodation would only involve individuals who reside in university-owned housing, and it cannot extend to bringing the emotional support animal into other areas of your campus. One other ASPA member question we received asked if there are cases where the ADA has gone up against academic freedom with regard to what is reasonable accommodation in the classroom. We were asked what kinds of norms or precedents have been set with regard to the clashing of these two sets of rights. There are numerous cases where a plaintiff has alleged that an institution has failed to provide a reasonable accommodation, and among the institution's defenses was that the principle of academic freedom and the importance of the courts showing deference to what goes on in the academic setting of a classroom overrode the reasonable accommodation request. Now, that being said, academic freedom does not permit instructors to decide if they will provide special aids or services for students with documented disabilities. In fact, an individual faculty member who fails to provide an accommodation to a student with a documented disability may be held personally liable for failing to act. So I would suggest you go back to the criteria we discussed when reviewing the ADA. There needs to be a request for an accommodation and then an interactive good faith process between the parties to determine what form that accommodation might take, with neither party being the sole arbiter in the matter. However, if you are able to demonstrate that the requested accommodation is unreasonable or would substantially alter essential elements of the course, this can impact the accommodation chosen. If you believe that you have an issue involving a conflict between the ADA and academic freedom, I would encourage you to start with a discussion with your HR office if it involves a faculty or staff member, and your disability service office if it involves a student. As you work your way through these issues, remember that academic freedom is a principle to which the majority of institutions aspire, but compliance with the ADA is required by law. Your faculty members will need to show deference to the recommendation of your DSS coordinator in deciding what is a reasonable accommodation within their classroom. There are a host of other issues which will come across your desk as a department chair as you're asked to fulfill the various managerial, academic, and supervisory functions, spot those potential legal problems, as well as understanding and applying your institution's policies and procedures. Many of these issues are worthy of their own webinar discussion. My goal today was to provide a broad overview of the most likely issues you will face as a department chair, describe the laws which apply to those situations, identify resources for you to use, and provide a framework for you to assess the issue. I hope that you found this overview helpful and that it's provided each of you with a guide to address legal issues you might face as a department chair before they escalate into much larger problems. Congratulations on your appointment as department chair, and good luck.
Great, thanks, Bethany.
Okay.